We have, we're presenting Financial and Healthcare Powers of Attorney, and this is taught by Marsha Goetting, who is our professor and extension family economics specialist. And we are so grateful to have her as a part of our university and a part of Montana State University Extension. Also co-presenting today is Emily Stanley, and she's the MSU Fergus and Petroleum County Extension Agent, and she's out of Lewiston. So I'm turning the powers over to them, and sit back and get ready to learn a lot. Thank you.
Okay, well, thank you very, very much, Caitlin. I am delighted to share some information with you. And I feel like this new present webinars that we're doing, it's almost like I'm being invited into your living room or wherever it is that you have your computer. And as you can see, I'm in my office, which is at home now, because we're all working remotely. And so the two screens that look like my ears behind me are actually my personal monitors. So I just switch from one to the other as the day goes on. And I'm excited to be able to share with you that we do have a Mont Guide on the topic of the financial power of attorney. And just as of last Friday, we now have the healthcare power of attorney publication done. So the things that I'm going to talk to you about, you will have a chance to review by looking at the Mont Guide and the other publication that we have available. Now, financial power of attorney, I'm sure most of us know that it's a written document in which we're going to give somebody else the opportunity to make financial decisions for us in case we're in a situation where we would need something like that. So let's take a look at circumstances. How about a National Guard person and they've been shipped overseas? Well, now the National Guard requires that all of their people do a financial power of attorney before they go. And in this case, this particular gentleman wanted to be able to have his wife renew a certificate of deposit while he was gone and sell a house. Another example of where it might be helpful is looking at a parent who's maybe getting a little bit forgetful. And if you can have that financial power of attorney signed before they expand into the later stages of Alzheimer's, then that daughter or that son can help them do their finances for the family. So I'm kind of curious, in our audience that we have today, have you granted somebody a financial power of attorney? So you've got a poll over there on your right. You are going to be able to answer yes or no. So that's a very simple question. And then just don't forget to hit the submit button that's at the bottom of the page on the very right-hand side. So have you granted someone a financial power of attorney? Okay, Emily, do we have some responses? Okay, we've got, well, unfortunately, nobody has granted somebody else a power of attorney. So that must be while you're attending this session so that you will be able to learn more about what a financial power of attorney is. Now, I've got another question for you real quickly. Have you personally been asked to be an agent for a family member, a spouse, or someone to handle finances for somebody else? And it's another yes or no question. So if you want to participate in that poll, let's see what we've got. Have you been asked to be an agent for some family member and therefore they're giving you a power of attorney? Yes or no, and then hit the submit button. Okay, Emily, what are our responses? Okay, we've got one person out of our participants that has, so that's very good. And that means that person has a sense of what's going on and might be able to give us a few pointers on what you found out in the process. And then we have several that don't have one yet. So let's learn more about a financial power of attorney. Now, before we do that, though, I would like to share what some people have said. A power of attorney is the power to steal. And here's an example that we've got. We've got a 79-year-old dad. He was in the Korean War. He was a veteran, and he was wounded, and he's on disability. Well, what happened is, even with that disability, he's been able to expand his finances during his later years. He's bought property in several states. He even had $300,000 in savings. So what did he do? Well, his shameless son had dad sign a power of attorney. And as a result of that, what the son did is he added his name to all the financial accounts. So in other words, what we've got is a joint tenancy with right of survivorship. And this included real property as well. So what happened next? Well, within a year, this son had withdrawn all $300,000 of the dad's savings. He took his own dad's VA checks, if you can believe it. And then we've got the shameless son. What he did was put dad in a nursing home. And then he told the staff, don't let any other of the adult children visit because they would take advantage of dad. Oh, can you imagine somebody doing this? And then here's another son. He was given power of attorney by his 87-year-old mother. And she only had $57,000 in her account. And what did this man do? He took it all. The other siblings did not find out about this until mom had passed away. So these are a couple of instances where it's really hasn't been an advantage. But let's take a look. What percent of people age 55 to 64 do you think have a financial power of attorney? And this was a research project that was done by AARP. So I was very interested in that. So you can say 73, 60, 55%, 38, or 29. What percent of people in this age bracket do you think have a financial power of attorney? And maybe I should have said given A. But anyway, it's who has what. Emily, what's our responses for this? Aha, well, we've got some people that thought 60%. You can look there and see the results on the bar graph there. And we've got let's see, some 20 odd percent. I'm going to move this out so I can see a little bit better. Well, maybe I won't. And so let's take a look at the next slide, because what it's going to show is that as we age, there are more people that have a financial power of attorney. Age 80 and above, a lot more, 73%, which is really kind of interesting there. Okay, what else can we learn here? Well, believe it or not, the state of Montana has what they call the Montana Uniform Power of Attorney Act. This was an act that was passed in 2011. And in it has provisions for the creation of your financial power. And then it also, thank goodness, provides some safeguards. And it is durable. People have learned that you want to have a financial power of attorney that is durable. In other words, it's still going to be in effect if you should go into a coma, if you have some reason why you cannot make financial decisions. Now, let's learn some terminology. The principal, we got to have these legal things. The principal is the person that's granting the power. And then we have the attorney in fact, or the agent, and that's the person who we're granting the power to. So we may name one of our adult children. And the neat thing about the form in Montana is it's statutory. In other words, when they passed the law, they had a sample form that was included. Also, they have the agent certification. And this agent certification is really neat because what it is doing is saying, hey, if you're going to be an agent, you need to realize that this is for the person. It can't be like some people that we had up in northern Montana. A niece and nephew came into the state and they actually locked their aunt into a bedroom. And what they were doing is spending that money on themselves. And now we've got that power to say, hey, we're going to go after those people. Because it was so hard when you gave a power of attorney. Well, let's just say people took advantage of it. So we've got the forms. That's good. And the responsibilities of the agent are outlined in that. But we want to go one step further. If you're going to have somebody do it, you need to talk with them. And then the agent, you need to tell them there's duties, there's circumstances, and by gum, there's potential liability in there. If you misuse my funds, keep in mind that you could go to jail, and that would be just fine for somebody that's doing something like that. Now, I do get asked at my meetings, can you appoint more than one agent under the Montana Uniform Power of Attorney Act? I talk probate a lot, so I got that confused. Can you name more than one agent? So this is a simple yes or no question. Okay, Emily, what do we got on that one? Can we name more than one? What do you think? Well, we've got 3 people that said yes, and we've got 2 people that are saying no, and then we have some that didn't answer. So let's take a look. Actually, the state of Montana says that you can do that. But if you're going to do that, keep in mind that your co-agents can use their authority independently. And that may not be what you want in your circumstance. Now, we may also find out that you've got these 2 that disagree about a particular action. So you've got 2 daughters, and one says, let's do this, the other one says no. And if they've had a history of not getting along, who knows? You might wind up in court. Then you're going to have attorney's fees, and you're going to have court costs. So it's a decision to think about. So what mom at one of my meetings said she was going to create circumstances where her daughters would have to get along. And so what the mom did was assign specific tasks in the power of attorney form that would be utilized by that. Okay, so what did the mom say? Well, mom said, I want you, daughter A, to be in charge of the personal property, stocks and bonds, any kind of bank financial stuff that needs to be done, and other things with the trust. And then her daughter B, who happens to be an attorney, that particular individual handles the real property. She even had commodities, so she had that down there, and insurance and annuities, and any kind of claims and litigation that happened to be there. So this is a mom, and I'd love to visit with her a few years down the road to see how well this has been working for her. Now, how about a successor agent? This is something we should think about. I mean, if you got a husband and wife and they're traveling together and they both have an accident. And this is what happened to my sister. She and her husband were on a motorcycle and they weren't going that fast. And lo and behold, they had that accident. Well, it's very handy that if you have somebody else to be that successor, because the one that you have, your primary one, may get sick, become incapacitated themselves, or maybe they said they would do it, and then later they decline to serve in that capacity. Now, keep in mind, though, that your successor agent has the same authority that was given to the original agent. So the Montana Uniform Act provides all these transaction categories, and there's a lot of them. And I thought we'd just quickly look at those. For example, you can make a check by real property, tangible personal property, stocks and bonds, banks and other financial institutions, for example. And then if you're in business, maybe this person is going to operate the business, insurance, annuities, trusts, claims and litigation, any kind of court settlement, any benefits from the government, retirement plans, taxes. See, you're handing over the authority, really, for this person to make any decisions that you could. Now, it even goes further. This law will allow you to amend or revoke or even create a revocable living trust for that individual. That individual can make gifts, and in Montana at the federal level, you can give $15,000 to as many people as you want to. So your agent could continue to do that if a grandma was doing it. And you can also create a joint tenancy with right of survivorship. Now, what else? You can waive the principal's right to be a beneficiary. And this might be in a situation where the person was going to inherit some money and that person wanted that to go down to the grandkids. We also see disclaiming property for the same reason. Now, here I am ranting and raving, and I forgot to say, if you have questions as we go along, I'd like for you to feel free to write that out in the chat room. And Emily's going to keep an eye out for those questions. And then what I will do is try to answer those if I can. Now, how about this power? Can an agent write a will for the principal? Can the agent write a will? So another yes/no question. Answer in the poll question area. I forgot the name there. Don't forget to hit submit. What do we see, Emily? What do people think? Okay, we've got some yes, we got some no's, and then no answer. I'm going to assume maybe you are answering number 3, you don't know. So let's see, can an agent write wills? No, that is one of the things they can't do, nor can they represent that individual in court. They just can't do those kinds of things. Now, how about paying the agent? Yes, I didn't realize that until I started working in this area, that person that you give the power of attorney to, the agent, is entitled to reimbursement of the expenses plus any reasonable compensation. The person may say, well, I'm going to charge so much per hour. And I think what happens a lot of times is if you have a child or a family member do this, they don't charge. They just feel like this is what I do as a family member. How long does it last? Now, you need to keep in mind, this only lasts until the principal's death. People think, oh, even after I'm dead, the person can still make decisions. No, they can't make that decision under the power of attorney. You may have assigned that person to be or nominated that person to be your personal representative. They can do the same things then, but it's under the guise of the personal representative, or you may be familiar with the term executor for that. Now, as you've got your power of attorney, you may run into a situation where there's an agency or a group that does not accept that power. So which of these do you think will not accept a financial power of attorney? Is it the Montana Department of Revenue? Is it the Social Security Administration, the IRS, or your local county clerk and recorder? Which of this do you think will not accept a power of attorney? So enter your choice in the poll question area there and let me know what you think. Okay, Emily, what are people thinking? Okay, we've got some thought it was the IRS, but the two that responded, Social Security Administration, you have it right. Okay. I didn't realize this till I worked on this either because I hadn't had that life experience. But the Social Security Administration does not accept a power of attorney. They will only recognize somebody that is a representative payee. And you just don't get that easily. The person has to, that's going to help out, has to prove that the individual is simply not capable of making some of those financial decisions. So they need a doctor's order to be able to do that. Now, my next slide here shows you there is a guide that the Social Security Administration has, and it gives this, if you're nominated to be a representative payee, or you apply to do that, say for your mom or for your dad, you can call this toll-free number, or you can order that booklet online. And I thought it was really, really helpful to see what the expectations were. But keep in mind, if you're a representative payee, you have to be able to prove where all the money went, which is a good accounting type thing. Give you some experience there too. So if we were to summarize with the financial power of attorney, it's really a low-cost, private alternative to a guardianship or conservatorship. Because you see, if you don't have somebody that's done this, let's say that your parent develops Alzheimer's and gets to the stage where they can't grant a power of attorney. If you want to be able to make those financial decisions for mom or dad, you've got to go to court. You've got to apply to be the guardian who will take care of mom or dad. And then the conservator is the person that is going to make the financial decisions. And you see, that's a court procedure. And who wants to take their mom and dad to court? And it can be a very sad and expensive thing to do. So that's why we want to grant a financial power of attorney to someone else to make those decisions. So if you want the mock guide, I've got the address here. We have that on our estate planning website, and we've got 43 others estate planning fact sheets as well. You just scroll down to financial, or it's called power of attorney, and then in parentheses, I've got the financial power. You can also then pick these up at your county extension office. So I would like to ask you then about your intentions with a financial power of attorney. Are you going to have an attorney write one for you? Are you going to use the statutory form for it, which is also included in the mock guide? If you've already got a power of attorney, are you going to review that copy? And did you decide, as a result of listening today, that you just decided you don't need one? So let us know what your intentions are, please. Okay, Emily, let's see what people intend to do. Okay, so we've got one that's going to take a look at that, and then we've got another one that is going to review. So that's good. Take a look and don't make marks on your original. Wait until you have the attorney, or that you're going to use the statutory form. Because the thing is, if you show that power of attorney with all these marks on it, you're going to find that a lot of financial institutions will not accept it because they don't know if you made the changes, or the principal made the changes, or somebody else. So keep a clean copy there for the original. Okay, so that's what I've got about financial power. Now let's look at a healthcare power of attorney. Have you granted someone, have you given someone a healthcare power of attorney? And that's another easy one, yes or no. Excuse me. Have you granted someone a healthcare power of attorney? Okay, let's see what we've got here. That was an easy one. And going to predict on this one. We've got somebody that does have one. Good for you. And we have a couple of people that say no. Okay, let's take a look at what a healthcare. Oh, before we do that, have you been asked to be an agent for someone else? Has somebody asked you to hold their power of attorney and make decisions about healthcare? Okay, Emily, what have we got here? Okay, we've got a couple of people that have said yes, that you've been asked to do that. And that's a real serious decision. It's one of those things I thought would be easy if I'd ever was in that situation. And yet with my brother-in-law, when the doctor says, uh, he's not going to make it, and I was one of those that said, well, if his brain is so damaged, and so I voted, yeah, pull the plug. And then later he starts doing better. And that made me think, those decisions, they're very tough. Okay, moving along, let's take a look at what Montana has now. I mentioned earlier about our publication, and this is one that right now is only available on the web. We have sent it to a printer, and we hope to have copies real soon. The other thing that we just finished up today is having this a fillable form. So in other words, when you call it up on your computer, you will be able to type in the things that you want for this. And we thought this would be make it a lot easier. So keep in mind, when this is available, the county offices will be notified. Now, I should tell you a little bit about the procedure for developing this model form. What we wanted to do, it started with the Alzheimer work group. And this is a group that I belong to. And what we're trying to do is respond to the need in Montana for Alzheimer education. And one of the things that resulted from the town meetings was that we need a healthcare power of attorney that is sort of standard. Not that an attorney can't change it, but that there's so many running around that, So I thought, well, let's get some groups together. So there is a healthcare law section of the state bar, and then there's the business, estates, trust, and taxation section of the state bar. And then me representing MSU Extension. We had members of the Alzheimer work group, and then later in the process, we had a couple of attorneys from Generational Justice in Helena, and then a physician. So if you can imagine all of these groups meeting together and agreeing on wording. I mean, there's just different perspectives, and I'm up there raising my hand saying, wait a minute, we need to have this in a language that people can understand. And so it was a good experience for all of us. I think at some time we were just ready for it to be done, but we got it done, and we're just thrilled to be able to share it with Montanans, and particularly now, and that's one of the reasons we wanted to get it printed, is there are people that are going through this decision making. What if I get COVID-19 virus? What are my healthcare wishes? Oh my goodness, do I have somebody that can handle my finances? So let's take a look at the contents. One of the things that our physician and the healthcare law committee was very concerned about is having some questions before you fill out the forms. In other words, some worksheets that have you think about how you want to be treated. So I just put in one example to share with you today, and that's question 3 that we have in there. And it says, of the following experiences, which ones would make you want to focus on comfort rather than trying to live as long as possible? So there we're looking at, okay, if I've got really, really bad cancer, how much pain do I want to have, or do I, before I die? So being in a coma and not being able to wake up to talk to loved ones was a choice. Not being able to live without being hooked on machines is another choice. How How about not being able to recognize loved ones, as in the case of dementia, and then not being able to feed, bathe, or take care of yourself? So we put some of those tough questions in there. Then you go to the model form. And in Form A, we have fill in the blanks. Who do you want to be your agent? Who do you trust with your healthcare decisions? And then think it through. Who do you want as a backup? Because there's always the potential for that first person to maybe even be in the same car accident that you are. So you need to think about the backup. Then we make a list of the agent's authority. So you need to take a look at that and think to yourself, do I agree with each one of those? And if there is one that you don't, you just mark it out and then you just initial it. What else do we include? Well, you have the opportunity. Do you want the authority to be immediately right at the time you sign it, or only when you're not able to make your healthcare decisions? And this is kind of one that we call a springing power. And I had it in mind for a while. I said, okay, because my mom had Alzheimer's, I said, if I'm diagnosed by two doctors with Alzheimer's, I want so-and-so to step in and make my healthcare decisions. Okay, my co-author, who happened to be the dean of the law school at the time, said, ooh, you're going to be in a bind if we've got situations where you've got family members that don't get along, and they'll say, well, let's have another doctor or let's have another doctor. So yeah, we need to think about when we want this to be in existence. What else is included? Well, there's some guidance and preferences that you can take a look at. And then there's the nomination of the legal guardian. You might say, why would you include that? Well, this is just in case. Just in case you have a couple of kids that don't get along, and there's one that might take the other one to court. Well, if you've already nominated a legal guardian, the district judge is really going to take that into consideration. So we put that in there as a just in case. And then we've got some other information about capacity and how you would define that. And then there's just administrative things in there. So it's one of those, you really do need to read it through. And that's why I don't like to read that kind of stuff on the computer. I always want to print it out. I may use scrap paper, but I really need to hold it in my hand. So as soon as we have those publications available, if you're like me, we'll be able to send those to you. You just have to request, and they'll also be at the county office. Then we have forms B and C, and we also have your signature and notary. Now, you don't really have to have your healthcare power of attorney notarized, but our decision was to include that because when you go through that process, it just gives it a little more legitimacy when you have something notarized, okay? And you don't have to file it anywhere. No, you don't have to do that. It's your original copy of your healthcare power of attorney. And of course, you can make copies. And one of the attorneys recommended that your healthcare power of attorney not only be shared with your doctor, your hospital, those kinds of things, but all of your children. That way, all of your children are on board. They know what your wishes are, and you don't have them fighting in the hospital room where maybe you can even hear what's going on, but you can't let people know what's going on because of your condition. So that's all of Form A. Then when we get to Form B, that's where we incorporated the Montana Rights of the Terminally Ill Act. This is an act that was passed years ago, and at that time it was called a living will. Well, since that time, we've passed the new law, and now what you're doing is making a declaration. And this law allows a person who is of sound mind, that's always in there, sound mind, to write a living will. Well, why is it that we're writing a living will? This is our way of letting people know about, and I hate to say the terminology, I say pull the plug. This happened at one of my young ag couples conference. But the sophisticated way is to say that we're going to withhold or withdraw life-sustaining treatment. If I'm in a terminal condition, there's a point at which I want that to be withdrawn. I don't want to live, for example, as a human vegetable. Okay? Your declaration, though, needs to be signed by yourself and two witnesses, but it does not have to be notarized. So don't sign it until you have your witnesses there to be able to say that they saw you sign this. When does it become operative? Well, first of all, your physician is the one that has to say that you're in a terminal condition. And, we're going to see some of that now. And then it becomes when you're not able to make those decisions by yourself about life-sustaining treatment. You can't talk to the doctor and say, no more. That's when it becomes operative. And then we need to look at what is life-sustaining treatment. And it's defined in the law like this. It's any medical procedure or intervention which, when administered to the patient, is only going to prolong the process of dying. It's you saying, don't do that to me, through the Montana Rights of the Terminally Ill Act. Then the terminal condition is also defined in the law, and you can read it there, but it's just saying in the opinion of the physician that it's going to result in death within a relatively short period of time. And of course, when I saw that, I go, oh my, how are they defining relatively short period of time? And the physicians may have that in their mind, but that would be something that, I would change that and say 6 months or whatever, but we're saying relatively short in the law. Now, Form C is optional, as well as Form B, but when we got to Form C, we kind of had a tug of war on this particular one of whether or not to include some information about religious preferences, where you prefer to pass away if you had a choice. Do you want to be at home, a hospice, a hospital, whatever. And then the other thing was the disposition of remains. Now, what is disposition? Well, let me show you Margaret. Here is a lady that verbally over Thanksgiving one year told her kids, here's the deal. I wish to be cremated when I'm dead. Okay, so they all heard it. Well, mom died. And they get to the 4 kids, and we've got the daughter saying, we need to honor mom's wishes. And then her 3 sons said, no way, absolutely not, no how. Now, if you're the funeral director for this, who do you think, whose wishes were honored by the funeral director? Do you think it was mom's through a daughter saying we've got to honor mom's wishes, or was it the sons? So you tell me by voting over there in the poll. Okay, what have we got, Emily? Whose wishes were figured? What did our people think? Okay, we've got just one that thought moms, and we had 3 that said the sons, and the 3 that said the sons were right. They had to follow, or they chose to follow, the majority of the children. So you can perhaps understand why it was the funeral industry that brought this law to the legislature saying we need this, because they're going to call it the Montana Right of the Disposition Act, And they're saying if you want a specific disposition, then you need to follow the law in the choices that are out there. Okay, what are your choices? Well, we could do a prepaid funeral contract, a written disposition, a signed affidavit, or a videotape disposition. So let's take a closer look at those choices. If you want a prepaid funeral contract, what you do is establish a funeral trust with a funeral director or have a funeral insurance policy. Those are all indicating your disposition, or yeah, disposition of remains. You could also have a written instrument. You could handwrite that saying, I want to be cremated, or I want to have this or that or the other. That can be typed. It can also be computer generated. So that's your second choice. Then, if you have this written instrument, you need to make sure that it is signed by yourself and then two witnesses. And those two witnesses need to be 18 or older, and they must be of sound mind. We always put sound mind in those. And there are some examples in the law. A letter of last instruction, a trust document, you could put it in there. And then they also listed a will. Now, I put up there on the slide, unwise choice. And here's the reason why. If you have a will, the thing is, you have to wait 5 days to submit a will to probate. And then once it's submitted, then the judge, the district judge, has to declare that it's valid. Well, if you wanted to be cremated and by the 6th day, that could be just a real problem in a family. So that's why I would recommend you not put it in a will. You have some other way of letting people know immediately, these are my wishes. And so you can see why the attorney was saying it's a good idea, even sending this out to the kids that, hey, this is what I want. And I know I had that discussion with my dad. I was saying I wanted to be cremated. And Dad, he was very upset about that. And I felt bad. And so as we continued the conversation, what I discovered is that in World War II, he was stationed in the Philippines, and a plane landed and then crashed, and then it burned. And he said, I will never, ever forget the smell of those bodies. So that was why he was not in favor of cremation. And we didn't cremate him, we knew what he wanted to have done. So there's my concerns about a will. The other thing is an affidavit, and it's simply an authorization to give another person the control. So maybe a mom says, I don't care, it doesn't matter, when I'm gone, I'm gone. Okay, then you might choose to have your daughter or a son or some other family member make that decision for you. And we do have in the law an example affidavit. And so we've got a copy of that in the mock guide, and we've also got a copy online so that you would be able to take advantage of that. And then that must be signed before a notary. Then it's kind of funny now to think about video, because we now have our CDs record things, but there is very interesting to watch an example of a rancher who videotaped how on somebody's camera how he wanted to have the disposition of his body. And so if you do that, there must be a written confirmation of your wishes, and then it must be signed by two witnesses that are 18 years or older and of sound mind. So those are your choices. Now, let's say you don't do any of these. You just don't want to make the decision. And yes, we've got people out there, but I think it's a responsible adult decision to make that decision so that your kids don't have to fight over something like that. So let's look at a variety of survivors. And so what the law did was allow a spouse to have top priority, then the children, parents, siblings, grandparents, And then last is a guardian appointed by the court. And that would be for somebody that they can't find any relatives, they didn't have children, they don't have a spouse. Then it would be the court's decision based on the guardian. So we do have a mock guide on that topic as well. When that new law was passed, I thought I got to get a mock guide out there. What are your rights over your remains? So that gives you more information about the choices that are out there in the forms and things like that. So I now have a question. As we look at this disposition of remains, which do you think would work best in your family? Do you want to have a prepaid funeral contract, a written disposition direction, a signed affidavit, or the videotaped disposition direction? Which of those methods do you think would be best in your family situation? Okay, Emily, what do we have as far as our participants today? Which method did they think is best? Okay, well, we've got one going for the prepaid funeral contract, and we have the written disposition. And certainly those two would be a lot easier than the videotaping, but it's still, with the cameras we've got today, be a lot easier to do something like that. And I'm aware of one attorney that also videotapes the signing of wills. And the reason is just in case there is an issue, that attorney will be able to show that dad was if there was a contestment of the will, shows the person was of sound mind when they signed that will. Okay, I think I want to ask you one more question here. What are your intentions about a healthcare power of attorney now that you've had an opportunity to hear more about it? Are you going to have an attorney write one for you? Those of you that already have one, are you going to review it? Are you going to use that model form? And last but not least, did you decide that you don't need one? So let me know in the poll question area. And Emily, while people are doing that, do we have any questions in the chat room?
Yeah, so one question is if a financial power of attorney can do so many things, like setting up joint tenancy with right of survivorship, then why can't they write a will?
That is a good question. And I think you'd have to say it's what the people that made the law decided on. We have these uniform laws that come in from the American Bar Association, and then every state makes a little change. And I don't know what changes were made as far as Montana when that particular bill was passed, but it's just that's what they put in the law.
Okay, another question. I know that financial power of attorney can have more than one agent assigned. Is that the same for a healthcare power of attorney?
Right, you can name more than one person, but just keep in mind if you do that, in some ways let's see. Sorry, no, I don't need to quit sharing. You can see me. Okay. I lost my train of thought there, Emily. It's two people for a healthcare power of attorney. Yeah, the thing is having both of those people agree. What are you going to do? Well, you're in the coma, so you can't decide. But there you are. Just imagine yourself in the coma watching your two daughters. And the two daughters are not agreeing about a particular doctor recommendation. Now, what are we going to do? And we've certainly seen the court cases. Remember the Karen Quinlan. We had another one where the husband wanted to do one thing and the parents did another, and it winds up in court. And we don't want to have our personal situations, I think, be on television. So just keep in mind consequences. It's not bad, it's not good. Just consider the potential consequences and how well the two people that you want to have be successors, how well they get along in decision making. So print materials, Emily has put that up so that you can see the materials at our website. And again, those will be available at the county extension office, and we'll notify Caitlin as soon as they're available.
Thank you, Marsha. I also placed the links on our Facebook page event, so they're ready to be posted. They'll be shared at about 1 o'clock today. I had it pre-scheduled. So thank you so much, Marsha and Emily, for this wonderful presentation. I know that I always learn something new whenever you present, Marsha, so I look forward to seeing you next Thursday, the 23rd, as well as the 27th. For those, if you have not joined our noon webinar series every day in the month of April, Extension faculty across the state are offering a different topic on a webinar. So tomorrow is taught by yours truly, and I'm teaching a class on how to get started with your electric pressure cooker, which some people refer to as an Instant Pot. Next Monday, we have Cooking with Kids, and that's taught by our extension agent, Jasmine Carbajal up in Hill County. And then on Tuesday, we have with a dietitian, how not to gain weight during the quarantine, and at least get those diet questions answered. And that's taught by our Associate Director of Extension, Dr. Suzanne Sluka. So we have a topic every day, and hopefully it's a topic that might be of interest to you. So thank you for coming, and we'll see you on another webinar. Thank you.